21, Mr. Visambar Prasad.
May I please, Your Lordship? It's a state appeal, Your Lordship.
Yes.
The only point for Your Lordship's consideration is during pendency of confiscation proceedings.
Has the order been stayed?
No, Your Lordship. We have complied the order. The contempt application was filed.
Mr. Sashi Bhushan, why did you not say before the single judge that confiscation was
that is the knowledge of the single because the direction was to release the collector to release the rights, not the judicial magistrate, Lordship. He suppressed the fact before Lordship.
No.
Kindly see the impugn order, Lordship.
Yes.
Page 19.
Yes.
In the given fact and circumstances of the case, this court direct the collector district magistrate. Page 19, impugn order, Lordship.
Impugn order, which paragraph?
Last page, Lordship.
Last page.
Operative part, last page. In the given fact and circumstances of the case, this court direct the collector is the अगर नहीं होता जुडिशियल मजिस्ट्रेट को ऑर्डर पास करते इन्होंने ओरल में कहा हम लोग को नहीं मिला था जो
क्या बहस कर रहा है मिस्टर ससी
लॉर्डशिप
आप 6A आप कम से कम 60 बार तो पढ़े होंगे अब तब ये बहस कर रहे हैं
thereafter I'm saying lordship
sorry
दो पॉइंट इनका है
tell us one thing now forget about all
lordship
we are not inclined to accept this order.
If LPA is not maintained, if any suppress the fact, he can file review petition. Not LPA, new fact cannot be raised in the place in the LPA. This is a well settled law, Lordship. Second thing, Lordship. ये रीट पिटीशन भी क्रिमिनल केस में क्वैश हो गया है उसमें हम डिवीजन बेंच
अभी आप हमसे जो हम पूछते हैं आपसे वो बताइए कन्फिस्केशन प्रोसीडिंग में क्या हुआ
हाई कोर्ट ऑर्डर से हमारा रिलीज हो गया हुजूर हमें ये ऑनरेबल हाई कोर्ट ऑर्डर से चावल हमारा रिलीज हो गया 2 साल पहले ही इन्होंने लिखा भी है कि नहीं सप्लीमेंट्री मेरे को दिए है कि नहीं दिए पता नहीं हमें
एप्लीकेशन वाज फाइल्ड
क्या करें
और उसके बाद में रिटर्न करना एक और बता रहे हैं हुजूर एक
एंड व्हाई वर यू नॉट देयर बिफोर द कोर्ट
यस लॉर्ड
व्हाई वर यू नॉट देयर बिफोर द कोर्ट व्हेन द मैटर वाज हर्ड एंड ही इज राइट
वी वर देयर
No,
काउंटर के टाइम भी मिला हमको देख लीजिए काउंटर के टाइम भी मिला गया इनको
it has been released
yes
so what does the record of the confiscation court say that under the orders of the court the cases आप उसके बाद just a minute mister आप उसके बाद रिव्यू में क्यों नहीं गए
your lordships there was a
now we are dismissing your appeal where we will be recording you have only protected your own skin your means your officers that you have challenged the order
एक और फैक्ट कह देना चाहता हूं
और कोई जरूरत नहीं है आप बैठिए
ना क्रिमिनल केस क्वैश हो गया हुजूर
उससे हमें क्या मतलब है
it was only
just a minute
फैक्ट हुजूर का
ये बहस गलत हो गया ना क्रिमिनल केस जब क्वैश हो गया तो ये पावर क्रिमिनल कोर्ट को था कहने का कि वो केस खत्म हो गया इसलिए रिलीज कर दीजिए
इधर हुआ ये सब लिया
it was only to the
therefore the learned single judge was absolutely wrong
no thereafter that's now इधर हुआ हुजूर एक केस में भी और
all right
the present memo of appeal
we will decide it in a different way heard Mr. Alok Ranjan learned counsel for the appellant state who has challenged the order dated 17/4/2019 passed by the learned single judge in CWJC number 6034 of 2019 directing the district magistrate Katihar to issue an appropriate release order of rice in question within 1 week of the writ petitioner furnishing sureties to the satisfaction of the district magistrate Katihar. Pursuant to the aforesaid order passed by the learned single judge, the rice in question has been returned to the respondent/writ petitioner. Mr. Alok Ranjan grieves that the court below that the learned single judge passed the order without ascertaining whether any confiscation proceeding had been initiated. On the date when the order was passed, confiscation proceeding had already been initiated for breach of a control order with respect to movement of rice, with respect to transportation/storage of rice. The learned counsel for the petitioner has further learned counsel for the appellant state has further submitted that even if there was no control order with respect to rice, it had to be seen as to the circumstances under which the rice was seized, which storage and transportation was found to be in breach of the Essential Commodities Act 1955. He further submits that no such order of release could have been passed during the pendency of the confiscation proceeding. First, be that as it may, we find from the record that when the order was passed by the learned single judge, there was no counter affidavit on behalf of the state to bring the aforesaid fact to the fore. Stop. Mr. Sasibhushan, Mr.
Kumar.
Sasibhushan Kumar, learned advocate for the respondent, submits that no wrong statement was made before the learned single judge with respect to the pendency of the confiscation case before the court below. Stop. In fact, from the last part of the order passed by the learned single judge, it is apparent that no direction was issued to the learned chief judicial magistrate for release of the rice, but the direction was to the district magistrate, who is the confiscating authority. First up, in any view of the matter, considering the order passed by the learned single judge, the rice in question has already been released, which they released to the concerned respondent / writ petitioner. First up, the hands of the clock in this situation cannot be turned back. First up, the act of court injures nobody. Separate line here. First up, we also find that no sooner was the order dated 17/4/2019 was passed, without taking specifically into account the pendency of the confiscation proceeding, it was incumbent upon the state to file a review petition before the learned single judge before the order could be complied with. First of that not having been done, the state has lost the right to challenge the order passed in the writ petition by the learned single judge. The appeal is thus dismissed.